Welcome, everyone, and thank you for joining us for today's Lunch and Learn. My name is Rich Williamson. I'm a partner at Robertson, Johnson, Miller, and Williamson in Reno, Nevada. I co-chair this task force with Hillary Fox, who is lead counsel with Allstate Litigation Services out of Minneapolis, Minnesota. The ABA TIPS Law Practice and Legal Department Management Task Force is dedicated to helping you with the business side of running your law practice. Today, we're excited to present the following webinar on the use of AI in the legal practice and the ethical ramifications. We would like to thank our co-sponsors for this program, the Business Litigation Committee, the Cybersecurity and Data Privacy Committee, the Plaintiffs Practice Committee, and the Solo and Small Firm Task Force. I would now like to introduce our moderator. Kathleen Strickland is a partner with Ropers Majeski in Menlo Park, California, where her practice primarily focuses on the defense of complex commercial litigation, cybersecurity, class action, and mass torts. Notably for this program, Kathleen chaired the TIPS Cybersecurity Task Force, ushered that task force into becoming a general committee, and served as its first chair. She also continues to teach for over 28 years in the trial advocacy program at Stanford University Law School, and continues to be named in the Northern California Super Lawyers. Kathleen, please take it away.
Thank you, Richard. I am very happy to be here to introduce Paul and Jeff. I heard them present on cybersecurity through the Daily Journal in 3 separate sessions. I thought they were excellent, and I wanted them to come and bring this to this platform. I also want to make a pitch for the ABA TIPS. We all need to learn about it's now artificial intelligence. We all need to learn about it. The ABA TIPS presents a national platform for lawyers on both sides of the case, like we're back in law school, to learn about this AI stuff. It's not going away, and we need to know about it. So that's why I mentioned it to Rich and Hillary, and I'm very happy to be here to present our 2 panelists. Paul Kiesel has been recognized by the ABA as one of the 12 techiest lawyers in America. He has been repeatedly recognized by the Daily Journal as one of the most 100 influential attorneys in the state of California. He has been selected as one of the nation's top trial lawyers by the National Trial Lawyers, and has been selected as one of the top 500 attorneys in the United States by
I know you did this. I'm going to stop you right there, Kathleen. You're done with me. Let's go to Jeffrey and then start the program. I apologize. I told you I was going to cut you off.
Okay. I said that I would refer you all to Kiesel.com, which you can. I'll see how much I get of Jeff's extensive bio as well. And I pared these down for this. But
it's actually Kiesel.law. .law, and for those of you that don't have it, a .law domain is a great domain. Kiesel.law. All right, sorry, go.
Okay, go. Jeff has been a civil litigator on behalf of plaintiffs for his entire career, handling complex matters in state and federal court. He's currently handling several class actions against Meta and Google regarding the interception of medical data without the consent of the patient. He has represented musicians such as the Temptations, the Motels, the Nelsons against Capitol Records, Universal Music, Warner Brothers, and Sony seeking royalty payments. He's represented the estates of Charles Bronson, Peter Sellers, and Richard Pryor seeking payment of home video royalties from major studios such as Sony, 20th Century Fox, Paramount, and Universal, and has handled cases against major automobile manufacturers such as BMW and Toyota.
Perfect. I think we're done. Kathleen, that's fantastic.
So here's what we're going to do.
Thank you.
We need all of you to put the questions in the chat box as we go along. Paul and Jeff would like to take questions out of the chat box as we go. So without further ado, I present Paul and Jeff.
Outstanding. Thank you, Kathleen. Really appreciate the introduction, and thank you all from across the country for joining us here. It's fantastic to have an opportunity virtually to talk to all of you. And of course, as we're dealing with artificial intelligence, a virtual presentation is the best way to do it. Jeff and I have done this gig before, so we sort of know what we need to cover, and we have questions we know you're going to have, and we're happy to answer for you. And so, Jeffrey, want to kick it off?
Yeah, thanks so much. And thank you for having us. We've asked ChatGPT and Bard in the past to do an agenda for these kinds of programs. And since we're going to be showing you other things that it can do, we're not going to bore you with that. Needless to say, that's something that you can do. You can say, I'm speaking to a bunch of legal professionals for 1 hour. Please create an agenda regarding artificial intelligence. And it'll do that. And if you want to make it shorter, you can say, make it for 5 minutes, and it'll do that as well. So let's get right to the substance of what we want to talk about.
And I want to sort of identify what Jeff just said, because he said it kind of quickly, but it's worth noting, and we'll talk about that through the course of the program today. So using ChatGPT, which is the OpenAI piece of this, or Bard, which is Google's attempt to develop AI, it's an iterative process. We've all grown up with LexisNexis and with Westlaw, where you do these queries. Remember the and/ors, the Boolean searches. Those days are gone. You can now basically have a dialogue in text, but a dialogue with the AI that allows you not to have to repeat the question you're asking, but to refine it as we go along. And you'll see that throughout the course of the morning or afternoon, depending on where you are in the country, how this works. Jeffrey.
Yeah, exactly. So what we're talking about is information that's generated by what's called an LLM, or large language model. They take an incredible amount of information, they dump it in, and then what the program is meant to do is to predict the next word in a sentence based on the previous word. And we're going to be talking primarily about 2 different types of LLMs today, ChatGPT, and Google has its own version, Bard, and they each have pluses and minuses and differences between them. So Paul's going to explain ChatGPT and I'll explain Bard.
And on the large language model, it's basically, just think of it as a huge trash compactor where they're taking bits of data, billions or trillions of bits of data, and crunching it together into a neural network where a computer is trying to figure out what you're asking and is generating what it thinks the best response is to your question. Now, some of you may have seen recently, there have been a series of class action lawsuits filed against OpenAI, saying, wait a minute, the data you're using, the large language model that you're getting your data information from, that's my private information. You're getting access to data you should not have. And that is an ongoing controversy. Yesterday, the FTC in Washington basically sent notice to OpenAI, we're going to be looking at the data set that you're using, what the scope of your large language model is that's creating your platform. ChatGPT, Jeff is going to do Bard, basically uses Microsoft, coordinated with OpenAI, and their data set stops in 2021. So they're current only as to 2021. Bard is more current, really up to today, and we'll show you some examples of how that works. But ChatGPT, even the paid version of it, ends in 2021 currently. If you buy, you can have a subscription as we do. We have a subscription to ChatGPT. It's $20 a month. And for that $20 a month, you have access to the full scope of their database, but again, limited to 2021. And the other good news and bad news is, do they limit you, Jeff, in terms of your use of ChatGPT?
Luckily, they do. They cut you off after 25 questions, and then you have to wait 3 hours, which is very useful because it's very addictive. And I've asked it to code, which we'll talk about a little later very briefly. And I was sitting there and I could not stop. And luckily it said, you've reached the maximum. It's time to walk away for 3 hours. Bard doesn't have that.
They don't age gate you. You're like 12 years old and you can use the system, but they do, the workaholics among us. They might even say, hey, Jeff, it's 1 o'clock in the morning. You've exceeded your time limit, but 25 questions is what you're limited to with ChatGPT. It's good. It's robust. It's got some challenges we'll talk about. Let's go to Bard.
Yeah, well, before we go to Bard, ChatGPT does have a good app if you're an iPhone user, number one. Number two is They are starting to allow add-ins such as Bing for it to become more up to date, but they just disabled the Bing add-in on the ChatGPT website. So for Bard, this is Google. And what it has done is also taken basically everything in the world, dumped it into their data set. And you would think because of Google Scholar, which has all of the court opinions in the country that have ever been published, that it would be much more accurate and it would not make things up, which in this world is euphemistically called a hallucination. And what we're going to be pointing out today at various points is that's really what you have to worry about when you're using either ChatGPT or Bard, is the hallucination. And that's why you simply cannot just cut and paste. So again, it's more up to date, but it is far from 100% accurate.
So unfortunately, a lot of lawyers from around the world didn't get the memo that said you can't really rely upon the information that it generates for you, the responses to the legal queries that you're making here. You need to be careful, and this is the ethics piece, and we'll talk more about that a little bit later on. You've got to be incredibly careful and site check and confirm the information that you're getting in your queries from the AI is accurate information. I'll give you some examples of how I've used it and how it's really been embarrassing what I've seen. But let's talk about some sanctions orders that many of you have read about across the country that have dealt with lawyers that have used AI to generate their briefs. And maybe I'll start with the lawyer in New York. You may have read about the lawyer who had a case against Avianca Airlines. The passenger was injured when a catering cart in the Iowa injured his knee, and he brought an action against Avianca. Avianca, it was filed in state court. It's important to note it was filed in state court. It was then removed to federal court, diversity jurisdiction, or there may have been a federal question. And the lawyer whose case it was not a federal practitioner. So he had to send it out to another attorney to make the appearance for him because it's the federal case. Defendants were a 12B6 motion to dismiss whatever the argument was. They brought it in their motion to dismiss, and the plaintiff lawyer went to ChatGPT and did legal research as to whether or not a claim was sustainable against Avianca Airlines. And it came up with 5 brilliant decisions as to why you could bring this case. It was a righteous case and it belonged where it was in federal court and ought not be dismissed. Well, Avianca said, wait a minute, you cited 5 cases here and we looked and we can't find any of those cases. Those cases, they don't exist. Now, the attorney, rather than saying, oh gosh, you're right, they don't exist, he doubled down. And the lawyer filed a brief that said, wait a minute, not only do they exist, but I asked ChatGPT, are you telling me the truth? Are these real? And Chat shockingly said, yeah, they're real. Of course they're real. We rely on databases and these cases are real. It's a problem. The federal judge did his own legal research. And somewhat shockingly, those cases did not exist. The sites went nowhere. And the judge set an order to show cause to plaintiffs' attorneys why they ought not be sanctioned for submitting a brief, which clearly was not the product of a lawyer's work product. And they, what happened there, Jeff?
Well, I mean, you mentioned the OSC. I have it in front of me. In the first paragraph, it says 6 of the submitted cases appear to be bogus judicial decisions with bogus quotes and bogus internal citations. And what the federal judge did on his own was he then contacted the Court of Appeals for the 11th Circuit, where one of the cases came from, saying, I'm having problems finding this case. And that's when it really turned into a nightmare. And that's the reference to the hallucination. I like to say when AI's hallucination turns into a nightmare for the lawyer. What happens at the very end of the story is the federal judge sanctions them $5,000, requires them to write apology letters to the judges that supposedly wrote the opinions that they didn't write. And the opening paragraph of the sanctions order sums it up nicely. It says, in researching and drafting court submissions, Good lawyers appropriately obtain assistance from junior lawyers, law students, contract lawyers, legal encyclopedias, and databases such as Westlaw and LexisNexis. Technological advances are commonplace, and there's nothing inherently improper about using them. Skip forward a little bit after he mentions Rule 11, which is never a good sign. He then says, respondents abandoned their responsibilities when they submitted non-existent judicial opinions with fake quotes and citations created by the artificial intelligence tool ChatGPT, then continued to stand by the fake opinions after judicial orders called their existence into question. And somebody has put in the chat, how did ChatGPT hallucinate? The reason is because, again, it's trained on all of the information that's dumped into it looking backwards. You're asking for it to come up with, give me all the cases that support the idea my case should not be dismissed.
But let me give you an example here, because I actually did this.
Okay.
I did some legal research. I asked my daughter to research. She's an attorney. I said, Lauren, do some research and tell me, can someone who suffered just property damage, can someone who suffered property damage in a fire assert a claim for emotional distress damages? Do you get general damages with a property loss only? And she came back and said, well, there's a couple of cases, Dad, that say you can get emotional distress damages for property loss only. So I said, I don't know. So I put a query in, and it gave me a citation, folks, to a case out of San Diego County against California Edison, where a fire was caused by a failure of electronic equipment. The case didn't exist. I knew the case didn't exist, but I then said, well, who are the attorneys on this case? Well, it said Gibson, Dunn, and Crutcher represented Edison, and Leif, Cabraser, Hyman, and Bernstein represented the plaintiffs, which is pretty good because Leif, Cabraser could easily have been the plaintiffs' attorneys, and Gibson, Dunn could easily have been the defense attorneys. Okay, I said, well, who represented the plaintiffs? Who's the plaintiff's lawyer in this case against Edison? And they said Boutros, a man named Boutros. Well, Boutros, and it said Mr. Boutros has been a partner at Leif Cabraser for over 30 years. Well, okay, so there is no case, there were no lawyers, and Ted Boutros is a partner at Gibson, Dunn, and Crutcher. And yet, Jeff calls that a hallucination. I call that mystifying. But it kind of made sense, except for the Boutros part. It made sense that it would be Leif and Gibson. Edison made sense that it was the defendant, but the case doesn't exist. And had I not done the due diligence, that hallucination would have been a part of my briefing. Jeff?
Yeah, and that's the issue. And the problem is it comes across, it looks very professional. There's citations, there's reporters, there's case names, and you would have no idea. So that was the case in the Southern District of New York. Quickly, there's been 2 other instances that I found so far. A poor young lawyer, a first year in Colorado State Court, submitted a brief trying to vacate a judgment, used ChatGPT, cut and pasted the night before the hearing. He's preparing for the hearing, trying to read the cases, can't find them, sends an email to one of the law clerks saying, I can't find any of these cases. I think he actually then said WTF, and basically had to withdraw his brief, and now he may have a problem. And this is happening now internationally. A court in Johannesburg also just recently issued an opinion. It was a dispute there regarding defamation. Somebody submitted cases, and the judge's order says, in part, the names and citations are fictitious, the facts are fictitious, and the decisions are fictitious. And so against that backdrop, courts now have been enacting rules requiring attorneys to certify that if they use ChatGPT or AI, that they've checked it. And these court orders fall into 2 buckets: concerns regarding the accuracy of what's being presented to the court, and interestingly, a concern specifically regarding confidentiality. So the Eastern District of Pennsylvania, for an example, has a certification that it says if any attorney for a party or a pro se party has used artificial intelligence in the preparation of any complaint, answer, motion, brief, or other paper, that attorney must, in a clear and plain factual statement, disclose that AI has been used in any way and certify that each citation to the law or the record in the paper has been verified as accurate. So you're already up against Rule 11. Now you're going to be certifying something under penalty of perjury. This could really turn into a nightmare. Similar order issued in the Northern District of Texas. There's a similar order in Montana. When you pro hoc in there and you want to practice in Montana, you have to be able to say, I'm going to do my own work. And Canada as well has now entered orders. And the attorneys in Canada are saying, look, this is a problem in the Southern District of New York. Why do we now have to deal with this? And the answer is because you can now add Johannesburg to the list of places where attorneys are not figuring out that you shouldn't be using this just by itself.
So let me say two things. The first is there is a way for you to help the program figure out what to do. There is a thumbs up or a thumbs down that you can use to advise the AI engine that it's mistaken. I think, is it a thumbs up, Jeff, or a thumbs down?
Correct. And that's how they train the AI to make it more of a process where it learns. When you're clicking the thumbs up or thumbs down on the response, you're helping train the AI so it gets it hopefully more correct the next time.
Correct. But look here, we wanted to start this program out talking about the dangers of artificial intelligence. There are some amazing benefits. What it can do is magical in many ways, a little scary. And the good news is this all confirms we need lawyers. Our brains are critically important to this process. But there are some amazing benefits that we're about to talk about, the reasons why you would want to use this AI format. But again, whatever you do, you must site check it all 100%.
Paul and Jeff, before going on to the benefits, there's a question asked in the chat. Is there a mechanism to report these hallucinations so that they can be removed from the respective AI programs?
I think Jeff just sort of addressed that.
Yeah.
But
it's kind of a yes and no. The best you can do is to give it a thumbs down. And for anybody that is interested and wants to get any of the orders in that SDNY case, feel free to shoot me an email, jeff@Kiesel, KIESEL.law, and we'll send it across. But by you hitting the down thumb, I don't think it removes the idea completely. And so no, is the short answer.
And so a couple things, I know there's some questions that have come in. So first of all, you're right. When you sign a brief, you're essentially attesting to the accuracy of what it is you're submitting. I think the courts are concerned. They want to make sure that lawyers really, if they're going to do this process, recognize that signing a brief may not be what it used to be in terms of the reliability of the contents of that brief. And yes, that's why you'd be sanctioned by filing a brief that didn't have accurate cases. But I think the courts have taken a bit of mercy. I was shocked, actually, Jeff, that the judge in New York didn't sort of remove that lawyer from the panel for a year, like suspend the lawyer for submitting, not only just submitting it, but standing by the brief.
I agree, especially because I think he was a 30-year lawyer. So he's somebody that certainly should have known better. Although I guess you could argue the first year just coming out of law school would know that you have to shepherdize your cases and do your own research. So
but the good news is, really, folks, it's a free service so far. I mean, it's $20 a month for ChatGPT. Bard currently, it's not monetizing Bard. It's free to do your research using Bard. There are legal services, not shockingly. There are companies that are trying to package alternative AI as an alternative to doing traditional research. And we'll talk about that in a bit. This company called Case Text is one such company that's trying to use AI in their actual, but that's a paid service for Case Text. All right, Jeff, benefits.
Well, I mean, I think we've hit on them somewhat. It can be time saving, it can be cost effective, and it's certainly accessible. As I said, the iPhone, the ability to use it on your iPhone is great. You're going to see it does have benefits, especially because it can do certain formattings and other tricks that would take a practitioner some time. And the biggest benefit, I think, is if you're up against a blank page and you just do not know how to start something, maybe use it as a launching point. But we cannot stress enough, you have to double and triple check it and do your own research. So Paul, what's the first example we should show them?
Well, why don't we start with the surreply? We got in the surreply on one of our cases, and I wondered, can you simply file a surreply? And for those of you that don't know a surreply, right, you have the moving papers, you have the opposition, you have your reply. And if the person that filed the opposition doesn't love the reply, they can try to do a surreply. And I wanted to know whether or not a surreply, what are we looking at, Jeff? Whether a surreply, there. So Jeff's typing in, I am an attorney in California and was sure with a surreply. Are you allowed to file that? That's the question. And there's always a disclaimer that tells you I am good up to September 2021. And then it gives you the rule of court, the California rule of court 3.1113, and tells you unless the court orders it, it's not appropriate.
So what you can do is, as Paul mentioned before, this is an iterative process. I don't have to now retype it again. I can say, are there any case citations that you can give me for your answer? So I'm not asking, again, the question from scratch, but I'm asking it just to build on that. So let's see what it says. Again, now here we go. It's going to name some cases, but it looks professional, looks real. That first case has a full citation to FRD. Who knows? So at this point of your research, what you really have to do is then go and see whether those cases exist or not.
And that is the cautionary tale. And you might actually find that that case doesn't exist. Or if it does exist, it doesn't stand for the proposition that ChatGPT tells you it stands for. So it's a really good initial starting point for research, but you can never, repeat, never just rely upon what it's spitting out to you as being accurate for you to then use in a brief itself. It's a really good starting point, though. You want to try the same question in BARD?
Yep.
And the thing about BARD, of course, is its large language model includes, as Jeff mentioned earlier, Google Scholar, which is all of the case decisions in the US pushed together. So Jeff is asking the same question of BARD. BARD is not time limited.
No, I'm not allowed to file a surreply on your behalf. So right now we're off in the wrong direction, but then it says surreplies are not allowed in California court proceedings. The California rules of court only allow for moving opposition and reply papers. So I can say the same thing. What are the citations for that answer? And are there any cases?
And by the way, maybe you want to misspell answer because it probably will recognize you. We'll do it next time. You'll misspell. Yeah, it's actually the case alone.
Well, let's see what it says. So it's given us the rule of court again, 3.1113, and now
it didn't do initially, right? It didn't give us the rule of court originally. It just gave us the statement. Just as we asked for citations with chat, we did it here with BARD, and now BARD does give you the correct rule of court.
And it also gives 3 cases with cites and everything, but the number of times that we have looked up the case citations, even sometimes when they include quotations, it's remarkable how it is just making it up.
So that would be one example. Let's see what would happen if we wanted to have it write a letter for us. So if I had a client in a case who had a personal injury claim and he wanted to know, is my recovery taxable? Is my recovery taxable? And so I tried asking the question 2 different ways, and you'll see we get 2 different answers here. I just did this morning. Jeff, do you have the question you could pop up there?
Yeah, it's not in the form of a question though, so it's kind of like
More of a statement.
Like Jeopardy. It's more of a statement. So let's put that first question in. And you want to do ChatGPT first?
Sure.
Okay. So here's the question. I'm an attorney in the state of California, had a client who was shot by a police officer. The matter settled for $16.5 million. Is the client required to pay any taxes, state or federal, for this recovery?
Same disclaimer. Now, what's interesting here is ChatGPT is getting it right in a way that Bard did not. I had run this on Bard and not on chat, and Bard saw through this by identifying the correct code section 104A2, which essentially says that personal injury damages are not taxable. And so generally it's not a taxable item. Let's do the same thing, ask the same question in Bard a second.
Sure. And then we'll ask it to draft a letter as well.
Right.
So here's Bard. It's thinking, it's very quick, and there's the answer. Well, there is an answer, I should say.
But this answer says the tax implications of a settlement for a police shooting, you consult the tax advisor, fine. But then it says the federal government taxes all income, including settlements for personal injury. Well, that's not right. That is specifically incorrect. But now we're going to change the question from what we had there, ask the secondary question. If you can, Jeffrey.
I'm doing it.
And that basically says, I'm a California attorney who represents a client who suffered personal injury. And now it tells you, generally personal injury settlements are not taxable in California. So go back up to the first question, and you'll see right there, it says personal injury is taxable. The federal government taxes all income, including settlements for personal injury. And yet the same engine, when asking the same question in a different way, different question, but the same issue, recognizes it's not taxable. And we know it's not taxable, but the watchword here is how you ask the question. What information you're asking to spit out is a factor of what it gives you. So you could see a very similar question asked two different ways gets a completely different answer.
Exactly.
Maybe have it.
Yeah, I'm just going to ask it to draft a letter to the client. Please
Right.
draft a letter, and I'll misspell some stuff. A letter to the client explaining your answer. And again, if you have a young associate or you didn't know the answer to the question and you were to stick it in and you saw the code section, that would kind of lead you to the code, and then you'd be able to do your research on ChatGPT. That same question on Bard might leave you with the misunderstanding or the misimpression that it is not taxable. And the last thing you want to do is rely on that. But here we have it generating a letter. Is the letter perfect? Would you want to change it? Of course. You'd also want to make sure that that IRS code section is correct, but you could copy and paste that into your document and then use it.
Pretty good letter. It's actually, I think you see how quickly this letter was generated. I mean, this is the blessing of what this is capable of doing. It's actually a personal letter to the client that incorporates some of the facts of the case into it. Which engine did we use here, Jeff? Was this Bard or Chat?
This is ChatGPT.
Yeah, and now let's take the same query and see what Bard does. Bard is not as good a writer
No,
as
it is
Chat.
not.
Just like that.
Oh, it's thinking. So again, we have that issue, right, Paul?
Yeah. But having said that, it's actually a better succinct statement of there are issues of taxability. Lost wages potentially are taxable depending upon how the release is written. Punitive damages are always taxable. That's absolutely true. Taxable punitive damages always. It doesn't talk about physical injury because really it requires a physical impact. But that would probably be a better way of describing the non-taxability of it. But you can see how each one of the engines gives a somewhat different response to the same question. I actually prefer when you're having letters written, having ChatGPT write it rather than Bard, but I like the legal research in Bard because it's using the large language model to pull its data set from.
Yeah,
So-
So we have a question in the chat from Kim Hogreave. How do these applications have the basis to make up a case? Where do they get the names of parties and court?
So again, what it's doing is it's predicting the next word in a sentence based on the previous word. It doesn't know the difference between the reality or not. And as far as it's concerned, it is making up a story to present an answer to your question. When we do legal research, we go to Lexis, we go to Westlaw, we know we're looking in cases, we know that that's important. It does not know that. And so the LLM is simply trying to give you an answer to your question, and it doesn't know that it's writing a movie script, or it has to be based in reality. And that is the
Let me
difference.
give you an example of that. When I asked it to do research on taxing a $6.5 million settlement because I was shot by a police officer, it doesn't realize, oh my gosh, that's a personal injury when you're shot by a police officer, and therefore the $16.5 million is not taxable. It sees shot, settlement 16.5. When you ask the same question as a personal injury, it knows, because it knows personal injury versus being shot by a police officer. It's predictive what the response should be, but not accurate depending on how you ask the question. Sorry, Jeffrey.
Here's another question,
Sure.
which everybody's thinking about, whether law firms should implement policies regarding their attorneys' use of AI, such as ChatGPT and Bing. If so, what do you recommend as far as the specific policies? We're talking about putting rails around AI to be implemented.
So
Yeah,
look,
I was going to say that's a great question, and it can be handled in a couple of different ways. And we're going to touch on in about a couple minutes the ethical implications. However, I'm aware of some large law firms that have just simply blocked access to ChatGPT or Google Bard, and a message comes up and it says, we encourage our attorneys to do their own research and you cannot access the site. Assuming that you're not at a firm that's going to do that, the best way to do this is to spread the word to all the lawyers at your firm, because as you'll hear, you have a duty of professional responsibility to make sure that you oversee what is going on. And again, we cannot harp on this enough. Because it looks so real, you're not tipped off that it's actually making things up. And so the important thing is to educate people, to get them to understand the power of it, but at the same time, it's very big limitations. And I think, Paul, what we may want to do is we may want to do the example of writing an opening statement, jury instructions, and formatting. So that way we have time to get to the ethical implications and the rules.
absolutely. So we really wanted to see if we gave the AI an opportunity to write an opening statement. And we want you to see sort of the magic of what it's capable of doing here. So Jeff, why don't we pull up that example then?
Okay, so we're going to use ChatGPT for this, and we'll say I'm an attorney in California and represent, and misspell, a 56-year-old woman named Beth who was rear-ended and broke her leg. Please draft an opening statement for the jury.
This is why we have legal assistants.
Yeah, seriously, boy, this is embarrassing.
That's okay. It's not a typing test.
Definitely fell that. So let's see what it does.
And it's pretty quick. So good morning. My name is Jeff Koncius, and I have the honor of representing Beth, last name, a hardworking 56-year-old woman whose life was upended due to the negligence of another. On May 1st, 2015, while driving home after a regular day, Beth was suddenly and violently rear-ended.
So if you notice, it starts adding facts because it's creating a story. And so here we go. She was adhering to all the rules of the road, which of course she was, but putting that aside, she was now rating at a red light when the defendant crashed into her. So the last sentence of this is great. A simple journey home turned into a traumatic event, one that has left her in constant pain, incapacitated, unable to enjoy life. So you see it's stuck in something. It says a red light. I didn't put that in as part of my prompt. It just decided to put that in there. So that is that. If you, let's say you're a young lawyer, you didn't know how to do an opening statement, you could use that as a basis. And then you could say, what are the jury instructions that I am going to need for my trial? And be specific.
Watch this. Yep.
So it refers us to KC, which in California are the California Standardized Jury Instructions. And then it lists the jury instruction numbers as well as the elements of the claim. Is this correct? Maybe not.
Probably.
Not. Probably not. Yeah, let's go with probably not. However, it could be a starting point for a young lawyer. So then we asked it to do that. And what happens here in California, in most places, you have to put that into a chart. So please create a chart of those instructions with the number, wow, geez, in one column and the title in another.
But by the way, even your mistyping, it recognizes, because it knows from the LLM, Jeff, that you don't do this very well.
Yeah, that's exactly right. But here comes the chart.
And you can basically import this into a Word document.
Correct. So
So
you
it's
can just
really-
cut and paste it.
Yeah.
So that is basically in a very quick nutshell, but we do want to get to the ethical considerations because that's a really important part of this. Because as you can see, it creates the things, it looks completely real. And that's how these poor souls out there who are just blocking copying it are getting into trouble. So the first one that we want to talk about is the duty of competence. That's ABA Model Rule 1.1. Hopefully everybody knows this one, that requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. You can't just start practicing in other areas of the law because ChatGPT can write something up. We don't do trust and estates here at the firm. I get a call from a trust and estates client, I refer it out. However, somebody could easily put in that question to ChatGPT, ask it to draft something, I send it to the client, and that is going to create a problem. And the model rule 1.1 comment 8, it flags this. It says attorneys must keep up with changes in relevant tech and reasonably understand its quote benefits and risks. And that's what's happening here. You must understand the limitations of the artificial intelligence that you're using. Paul, confidentiality?
Yeah, let's talk about this one, folks. This is really, really potentially dangerous. So when you're using AI, whether it's Bard or ChatGPT or any other service that uses artificial intelligence to do your research, your data set is going somewhere, and is going somewhere where it's going to be viewable by others. Bard tells you in the terms and conditions that they utilize and look at your data. There may be human eyes that are looking at the information you're sending up to them, and they will use that for further marketing purposes. So what that means is many of us have, in fact, all of us have an attorney-client privilege with our communications with our clients. When you start doing research and putting in information to the AI, which is confidential, maybe highly confidential, maybe attorney eyes only confidentiality, which we have in a lot of our cases. We have protective orders that say attorney's eyes only. When you put that data into an AI, you are exposing for yourself the risk of communicating attorney-client information. There are now programs where you can take depositions and ask AI to summarize them. It'll do that. There are medical records that can summarize the medical records. Hundreds of pages of medical records can get synthesized and summarized in seconds. But you're taking your client's protective medical data and sharing that online. Model Rule 1.6 basically says a lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. So when you start putting data online, you're telling somebody else that you are this individual's client. 1.6c says a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. And when you're putting all this data up there, you are violating that rule since you don't have the right necessarily to share that data. Jeff?
Well, that's a real problem.
Of course it is.
Big problem. It is a big problem.
And it's not just, we want to flag the problem. We use a great program here, which I won't mention by name, but we were getting a demonstration and they were very excited about the new AI add-in as part of their program and what it could do. And we asked, who is that powered by? They said OpenAI, which is the company behind ChatGPT. And we said, okay, if we're looking at documents and we're using your product, and OpenAI is doing this, what's going on there in terms of confidentiality? And it said, well, that's subject to OpenAI's policy, which has a limited policy, but it's still there. It sits there for 30 days, if not more, and you really have to understand it. So whenever you see anything that's talking about powered by AI, you have to wonder, where is your information going? Which brings us to the next one, supervision. ABA Model Rule 5.3. As you may know, should know, lawyers can face ethical violations for the conduct of non-attorneys that they supervise who act at their behest. Again, you can't just use AI and send the information out the door. Comment 3 to Rule 5.3 says this applies to outside the firm as well. When using such services outside the firm, a lawyer must make reasonable efforts to ensure that the services are provided in a manner that is compatible with the lawyer's professional obligations. It flags investigators, printing services, and cloud storage. And what we're adding to that is, of course, AI for the reasons we discussed. We have 3 more that we're going to talk about. What's interesting is that the first 3 were from research that we did, thinking about what rules could be impacted. We then asked ChatGPT and said, what ethical rules do you think attorneys should be mindful of? And it suggested the next 3, including the next one, Paul.
Yeah. And Kathleen, will you say something?
Yes, before leaving that topic, I mean, that was the basis of the lawsuit filed yesterday against Google in the Northern District of California for using this data that had been fed into to train AI that was personal PII data.
Right.
Protected data, and they are seeking, the suit seeks a temporary stoppage of the development of Google's technologies until safeguards can be put in place.
Yeah, exactly.
And
And
that's filed by the Clarkson law firm.
they may take the position when you put the information online, you did that query, you gave us the right to use that data, and we simply used the data. We didn't look at it. We didn't define it. We just put it into the garbage compactor, and this is what came out. Okay, but unauthorized practice of law, because we felt like this feels a little bit like unauthorized practice of law, because when the lawyer in New York had a brief written by Bard and then submitted that to the court, Bard is actually practicing law, we felt. And so we asked Bard, tell us about the unauthorized practice of law and ABA Model Rule 5.5. And Bard says, actually it was ChatGPT, says, all AI tools might be capable of generating responses that could be construed as legal advice. If an AI tool is used to communicate directly with clients or others without proper oversight or review by an attorney, it could be considered as the unauthorized practice of law. Attorneys should ensure they maintain control over the advice provided to clients and do not delegate this responsibility to artificial intelligence. This is artificial intelligence telling you, be careful of what we're giving you.
Exactly. The next one that it suggested, ChatGPT that is, it suggested ABA 8.4 and the comment which relates to bias and fairness. This rule states that it's professional misconduct for an attorney to engage in conduct that is prejudicial to the administration of justice, which could include allowing biases presented in AI tools to influence their legal representation. That's ChatGPT talking there. I then followed up and I said, I'm a little confused by that. How could it be biased? And it responded with this. It has 3 different biases that you have to watch out for. Representational bias, which means that the training data that was put in is skewed. Confirmation bias due to commonly held beliefs, because again, if it's trained on everything going backwards and those beliefs all come from a certain area, you're going to get an answer similar. And contextual bias, how the data is presented. There were early reports of people purposely trying to ask it to do things that we would not think that would certainly offend people's morals today, and it would actually act on those things. They're now starting to put guardrails in place to kind of keep it within a range. But as with anything else, if you start putting guardrails in place, you're obviously then narrowing the response and the information that's going into it, which itself is biasing the result. And the last one is transparency. That was also represented by ChatGPT. I'm sorry, suggested by ChatGPT.
Right, that's model rule ABA 1.4. And what that's saying is you need to let your clients know, if you're utilizing AI as a resource, that that's the source of information you're communicating with them. You have to be transparent about where you're getting the data you're sharing with the client. Those three things, transparency, bias and fairness, and unauthorized practice of law, is what the AI itself said you need to be careful of. And we agreed to that. We actually identified that before AI did, but we agree with AI on this one. It's correct.
And there's a question in the chat. It says, is there any type of document review that can be assisted with the use of AI? As Paul alluded to, there are companies where you can upload, for example, depositions, medical records, etc. There's actually also a company, I think it's called Chat PDF, that I used. It's a $5 a month program. I uploaded a deposition transcript that was not sealed, and I was not impressed. So again, these things are learning though, and we expect not too long from now that will certainly be something that you can do. Upload a 150-page deposition and say, summarize this, and then it comes back. But you have to be mindful of the information that's in that transcript. Going back.
So I have a question. As
Sure.
all of these big companies are taking the ChatGPT chat box and developing their own programs like AT&T to train assistants and things like that, Oracle, the big ones, Salesforce. What we talked about this earlier, and I asked you and Jeff about it yesterday when we spoke. What is the law practice doing to get their own ChatGPT chat box
So the
vis-a-vis
answer is
practice of law?
that Westlaw or LexisNexis are hot on the trail of finding the most efficient and safest way to roll this out. They've not yet done that. I expect that they will. There is a product we talked about yesterday called Case Text, CASE-TXT. I just did a demo with them earlier in the week, in part because I knew we were going to do this program today. And Case Text does use their own internal large language model of legal resources, from statutes to case law, from DC to Seattle. They have all of it mashed together. It's not as clean a product as Bard or ChatGPT in terms of its quickness to respond or its facility to give iterative responses. So you need to keep asking queries if you want to refine what it is you're looking for. But what it does do is it gives you citations to cases when you ask it the questions, and you can click on a hypertext link that actually takes you to the case and to the page line that it's referencing in its answer. So there's a little more security to know, unless they've literally created a case and a citation and totally fiction, which I don't think they have, that you can feel a little bit more secure that when it gives us case citation, Kathleen, it's actually a case you can rely upon. But this is really, in terms of the legal marketplace, it's just starting. And I imagine that 5 years from now, it'll change the world that we're living in.
And
Well, there's a note in the chat that Thomson Reuters just bought Case Text.
So I'll answer it this way, because I asked that question because I knew that Thomson Reuters, Laura, had purportedly purchased it. The answer is they have a deal in place for $650 million. It's not closed, but there is something on the table for Thomson Reuters to purchase Case Text for, in fact, $650 million, but they're still not completed that purchase.
So I want to, at this point, and we'll just go back to sharing my screen for a second, and thinking of the rules of professional conduct, and we're in ChatGPT. So write a rule of professional conduct for attorneys regarding the use of artificial intelligence in their practice.
What a fun way to end.
We'll see.
Don't.
Yeah, exactly. What's great about this is you're going to see it does what we lawyers love to do. It has subparts, it has defined terms, it has all sorts of stuff. So it's imitating a lawyer really well here. So a lawyer shall remain competent in the practice of all professional duties, including an understanding and the benefits of risks and ethical implications when using AI. And now we have A, 1, 2, 3, then we have C, D, E, F. And so it's really a fantastic thing. Again, this is a great tool. It's a great starting off point. It's a great jumping point, but should it be your only place to do your legal research? Absolutely not, because we're doing these, Paul and I have been doing these panel discussions. And what's great is more and more lawyers are getting into trouble for using it. So that section of it is getting bigger and bigger, and it helps us point out the ethical pitfalls of relying on it solely.
Right. In fact, when we started to do these programs back in April, it was well before a lot of these challenges just came up, and we're able to point back and say, we told you so. But again, Kathleen, this is, we're in the early stages of what will be a remarkable, I think, seismic shift in some ways, the practice. The danger, folks, is this, and this is why the law needs to remain within our human brains. These are backward-looking devices. It's only looking in our rearview mirror. They're looking back to the framers of the Constitution, somewhat like our Supreme Court. But we are a forward-thinking group of individuals. And in order for the law to expand, in order for the law to recognize that what we have in product liability, and the reasons why we put product liability in place in this country to protect people who are vulnerable, it's why social media companies may be responsible for harms they cause to our adolescents, because there are harms that the protections, the immunities that they have need to go away. But if all we're ever doing is looking in the past, and the past has given protection, we're not going to get the protections in the future. We need our own life experiences for the law to continue to expand, or just living in the past. Jeffrey?
I completely agree. Although I would add to that, AI does live somewhat in the future because it hallucinates and makes things up. So what we need to do as lawyers is to make sure that while we're pushing the boundaries of the law forward or expanding the boundaries of the law, we do it in a way that's compliant with our ethical obligations to the court and to our clients. It does not serve your client at all using one of these search tools and just sending it out the door without using your independent research skills and knowledge of your practice area.
Well, you know, ChatGPT 4 has been fed 1 trillion bits of data, more than the billion that Google had. And there are sources out there that believe in free speech vis-a-vis AI. There shouldn't be any rails on AI. There's like this company called Wizard LM Uncensored, an open assistant that don't believe in any rails on AI and free speech. And they're promoting free speech. And I just think that it can really get out of control, that the lawyers need to be at the forefront. The FTC is trying to put some regulations around it, looking into the source of all the data being fed to these large language models, but it's concerning.
I'm standing up because my Apple Watch says after an hour, you need to stand up. You've been sitting too long.
Well, it's good. Your Apple Watch has has a perfect sense of time there, Paul. I really appreciate it. So unfortunately, that is all the time we have today. But we want to again recognize the co-sponsors of today's program, the Law Practice and Legal Department Management Task Force, the Business Litigation Committee, the Cybersecurity and Data Privacy Committee, the Plaintiffs Practice Committee, and the Solo and Small Firm Task Force. Most importantly, we want to thank Kathleen, Paul, and Jeff for an amazing program.
Thank you, Richard. Thank you all. Be well.
Yeah, thank you for having us.
Thank you, everyone.
Bye.
Bye.